How many times do I have to tell you? The answer is no. We are not going to settle this case. We will see you at trial, and we will let a jury determine the value of my client's injuries. You want to know what this is all about? Come join me for a walk through the neighborhood as I share with you my conversation with the opposing attorney when he kept asking me to settle this case. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, my client sued various doctors and hospital staff, claiming that as a result of their carelessness, she suffered significant harm and injury. My client suffered permanent physical harm and injury, and she was outraged that within the first 6 months, the defense refused to acknowledge they did anything wrong. She was outraged that the defense didn't recognize immediately that this case should be settled. Number one, that they did everything wrong. And number two, had they done everything right, none of her injuries would have occurred. Because of that outrage, because of her emotional state, she gave me clear-cut orders that basically said, I am never going to settle this case. I want to go to trial. I want a jury to see what happened to me. I want a jury to put a number and a value on the extent of my injuries. And she believed that by going to trial, 6 members of the community would go ahead and not only give her justice, but would give her a very, very substantial verdict in her favor. Why? Because her injuries were in fact disabling, they were permanent, and they were very significant. All right, so now we go through the entire litigation process, 2 long years of hard-fought litigation. Now the case is on the trial calendar, and we are approaching a trial date. As we approach the trial date, the defense attorney calls me up and says, hey, Gerry, listen, we've had this case reevaluated. We would like to start negotiating and see if we can resolve this without the need to go to trial. I said, I'm happy to listen to any offer, but you already know my position. My client has made it very clear that we have no intention of settling this case, that my client wants to go to trial and get a verdict. Now, the defense attorney acknowledged and understood that. However, he still wanted to go ahead and try and get settlement discussions going forward. Even though I told him outright, I said my client has no interest and my client will not settle this case. About a week later, I get a call from the same defense attorney on the same case who said, listen, my clients and I are eager to try and settle this case. I said, so make me an offer. If you make me an offer, I have an obligation to take it back to my client and discuss it. So give me an offer. Now they proceeded to give me a 7-figure offer, which was respectable, but I knew right off the bat my client would never go ahead and agree to that. And I said, thank you for the offer, but you already know our position. Our position is that we have no interest in trying to settle this case. So, despite that, I still had an obligation to take that offer back to my client, to now discuss it with her, to explain to her the risks associated with accepting that offer, as well as the risks of rejecting the offer, in addition to the risks of going to trial. And you should know something that not a lot of people talk about. When you go to trial, even if you believe you have the best case in the world, even if you have the best medical experts in the world to support your case, even if you believe you have the best lawyer in the world, in New York, to go ahead and represent you, there is absolutely 100% no guarantee that you will win your case. And you're thinking, oh, come on, how can that be? How can it be? It's because there are 6 members of the community who now have to decide whether you, the injured patient, are slightly more likely right than wrong than what you are claiming is true. Whether our experts are more credible than the defense's experts. Whether what we are saying is more likely true than not. If the jury does not agree with us, it doesn't matter what kind of case you had, it doesn't matter how great you thought your case was, it doesn't matter what your experts had to say, it is ultimately at trial the jury's function to determine whether we have shown that we are slightly more likely right than wrong and whether you are worthy of a verdict in your favor. Just because you suffered significant harm and injury does not automatically mean that there was wrongdoing. And it will be up to a jury to make that decision, not a judge, because those are often questions of fact. And a jury is there to decide who is more believable. And if the jury comes to the conclusion that the defense is more credible, then you may be out of luck, and now they side in favor of the doctor and the hospital. In that instance, you will lose your case. So now, after having a discussion with my client about the risks and the benefits associated with an offer, as well as the risks, the benefits, and alternatives of actually going to trial, my client said exactly what I expected her to say. There is no freaking way I'm going to accept this settlement offer. I said, okay, I'm going to let them know. I'm going to let the defense attorney know, and we'll go from there. So now I relayed that response back to the defense attorney. He said, listen, my clients really want to settle this case. We acknowledge that, you have the better case than we do on terms of liability, but we really think this case should be settled. Well, guess what? I said, you understand my client's position? She was frustrated, and she was upset, and she was angry that you guys never acknowledged what had occurred and never took responsibility. And because of that emotional ego, because of that emotional state, she now is refusing to go ahead and settle. I said, if you'd like to make another offer, you're welcome to do so. We'd be happy to entertain it. But I'm telling you right now, I've spoken to her, and she is adamant that she's not settling this case. All right, so now we know where we stand. Well, a week later, I get a call again from the same defense attorney who said, listen, we have reevaluated the case once again, and now I have an additional offer for you and your client. I said, okay, you know our position. What's your offer? And now they literally doubled the offer. Instead of $1 million, now the offer was $2 million. Now here's something fascinating. Normally, I, as the plaintiff's attorney, will make a demand asking the defense for a particular number that we feel that the case is worth in order to settle the case. And then the defense will come back with a counter offer, and now we'll continue further discussions. In this particular case, I did not make any demand at all because I knew what my client's position was. I knew I didn't have authority to settle the case for any number, so therefore I did not make any demand. The offer that the defense made was a single-handed offer, meaning that they came up with that number on their own. And now, instead of having the normal back and forth negotiations where I might come down in my demand and he might increase his offer, that didn't happen. So instead, they made an initial offer of $1 million, which was rejected. Now he comes back a week later and says, I'm going to double the offer to $2 million. Now, what does that tell me? It tells me a couple of things. It tells me, number one, that they really don't want to go to trial. At least at this range, this type of number, this type of settlement offer is very substantial for this particular type of case and this particular type of injury. I knew that the true value of my client's injuries was somewhere between $4 to $5 million. Now, that's not something that I shared with the defense, but the reality is that I knew the defense knew that as well. And that's why they were making this offer. And I also recognized that because they were making these single-handed offers without me negotiating, that they realized they have a substantial problem in defending this case. So now, he offers $2 million, and I tell him outright, I said, thank you for the offer. I appreciate the fact that you're trying to negotiate, but my client again has made it very clear she will not go ahead and settle this case. So despite the fact that I knew what my client's position was, I still had to go back to her and tell her about this new increased offer. I told her they've now increased the offer to $2 million. And she said, and I knew what she was going to say, absolutely not. Okay, so I contacted the defense attorney. I told them thank you for the offer, but my client rejects the offer. We will see you at trial and let a jury decide. All right, is that the end of the story? No, it's not. Because next week, the following week, I get another call from this defense attorney. And he said, listen, how about we go to lunch? I said, thanks, but I don't have time. What's going on? He says, we have reassessed the case again, and we would like to resolve this case now without the need to go to trial. I said, well, thank you for that, but you know our position. He said, we are now going to increase our offer once more. We are going to offer $3 million in order to settle this case. I said, thank you, but you already know our position. Nevertheless, I will go back and tell my client about the offer. And that's exactly what I did. My client listened to this third offer, and I noticed something different about her. I noticed that she was getting a little bit softer. Maybe I caught her on a day where she was emotional, where she was thinking about what had happened to her in the past. I think she was thinking about her kids and her grandkids, and she didn't outright reject the offer. She was still upset, she was still angry, but not like before with the other 2 prior offers. But still, she turned around and said, I'm not accepting this offer. Okay, again, I called the defense attorney back. I said, thank you, but we are not going to accept the offer. So now, within days of starting jury selection to go ahead and start this trial, I run into my adversary in court on another matter. We start talking about the cases that we happen to be handling that day. And of course, the conversation turns to this particular case, the story that I'm telling you about. He said, listen, my principals and even the doctor wants to resolve this. They don't want to go to trial. They don't want to do anything here in this case. And he's like, what can you do to convince your client that this case should be settled? I said, honestly, the only thing that's going to make this go away, that I think I can get my client to accept, even though she's adamant and refuses to settle this case, is if you came up with $6 million. That's my opinion. Now, the attorney stopped for a second. He was silent for a few moments. He started thinking about it, and he said, let me go make a call. I'm thinking, wow, that's not the response I was expecting. He goes out, makes a call, and about 20 minutes later comes back. I'm still in court on this other matter I'm covering. And he says, come on, let's go outside and talk. He comes out to me and says, listen, I can tell you something in confidence. I can tell you that if your client will agree to $6 million, I can offer that money to you right now, if it will settle the case. I said, that's quite impressive. That's quite a jump from your initial offer of $1 million, and even the $2 million, and even your final offer of $3 million. I said, I expect that my client is still going to say no. However, what's going to happen? I have to call my client, I have to let her know and discuss it with her. Now, I did not want to have this conversation with her over the telephone. So now I called my client up. I said, listen, I need to come talk to you. I need to prepare you for trial. And there have been some interesting discussions with the defense attorney. She said, you know my position. I said, that's fine. I'm going to come by later this evening, and you and I are going to have a chat. So later that evening, after work, I went over to her home. I sat down with her at her kitchen table, and now we had a conversation. And I relayed to her exactly what happened in court with my opponent. Now, when they came back, knowing that if $6 million would settle the case, we could do it, and the case would be done and over. Remember what I said at the very beginning? She was willing to settle this case. She believed her injuries were worth $5 million. Now, here we have an offer of $6 million. And when I told her that we had the possibility of a $6 million offer, all the blood drained from her face, all the hatred, all the anxiety, all the anger that she had built up over the last 2 years just washed away. Because everything she was hoping to get not only would come true with this settlement offer, but it's exactly what she wanted plus another $1 million on top of that. By the time I was done talking to her, she turns to me with tears in her eyes and said, take the offer. I was shocked. I could not believe after all this time, my client now recognized that her case should be settled. She made the right decision, and I told her that. I said it was a great decision for her without the uncertainty of going to trial, without knowing what would occur in the future. I said this was a guarantee. And after the attorney's expenses, after the attorney's fee, I gave her the final number of what she could expect to receive, which was a very, very substantial amount, much more than she ever expected to receive for her particular injuries. So on the drive home, I called my opponent. I said, listen, I just want to let you know I spoke with my client, and my client will accept your offer if you offer $6 million, and we can settle this right now. And you know what he said to me? He said, done. Case settled. Send me the paperwork. So why do I share this story with you? I share it with you just to give you a look, an inside look, into what happened with one particular injured patient that I was helping during the course of her medical malpractice case. The settlement negotiations were very unusual and rarely, if ever, occur like that. You know, I recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York, and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.